morning, everyone. My apologies for being late coming in, but I wanted to give you guys some information regarding to the um the case that was overturned in regards to Roscoe, Pee Wee Roscoe, aka his real name is Jimmy Winfrey. I wanted to bring you guys information. I'm gonna let the computer read to you guys, but before I do that, I want to show you the what Mr. Steele was saying in regards to what the state already knew, and it's like they're playing games in this whole case, throwing everything but the kitchen sink in regards to the stuff that they're trying to taint the juror's mind. Okay. Oh, Robin, I hope your surgery went okay. I'm gonna pray for quick healing for you and Rosie. Rosie had surgery as well. My prayers goes out to you guys. All right, let's go ahead on and let me play the from the court today, and then I'm gonna play the little clip, the article from the overturned the case. Okay, all right.
I don't have can I make a motion and then just let me know if I can do this tomorrow so I don't waste the time. Is that okay? Not waste the time, but take up the time.
What motion do you wish to make, sir?
So I made it at the bench. The state asked Honorable Agent Ray C. whether Mr. Winfrey pled guilty shortly after the October phone call that was played over objection, where he was, where an unknown person states that another unknown person stated he would get a Porsche.
Yeah, we covered that already. So what's you have an additional objection, sir?
Yeah, so this is my issue. So the state said, did he plead guilty? Knowing.
But we covered that, Mr. Steele. We covered that. So what's the additional ruling on it?
Knowing that was not a guilty plea. That was a coerced guilty plea is not a guilty plea.
But we had the discussion at the bench, and I told you that you can inquire into that depending upon what was testified to.
Okay, and I'm going to do that. I propose, but my point is that was so low blow to say a month later a man who was coerced by a Superior Court judge in Cobb County pled guilty. That I don't know if I can overcome that. Because the impression is that Mr. Winfrey was being rewarded for his guilty plea. The state knows that guilty plea was not.
But we don't know as I mentioned earlier, the bench, we don't know the circumstances of why that particular first guilty plea was rejected. I don't think it's relevant for our purposes. I think the state said they weren't going to get into it. So again, the second time, because we covered that up at the bench, do you have anything else you wish to add to that? I don't think the state was trying to insinuate anything. If you want to test that or reason, because it might go to bias, it might go to motive to misrepresent. So
it bothers me a great deal, and I'm surprised, but I'm not ever in the mind of the court. It doesn't bother the court because it doesn't go to bias, and the state knows exactly what they did. They know, and you know.
I don't. The first time that I knew that there was an appellate opinion is when you told me, and that's it. I don't have any other knowledge of that.
Well, I read every opinion, and Winfrey versus State specifically states, and it gives what happened, that the Honorable Judge Staley in Cobb County coerced a human being to enter a guilty plea. For the state of Georgia to say, did he plead guilty a month later? That to me is beyond the pale. And I would like the court to.
I think that's just them asking. They're not asking why, which would be improper. But because it gets into evidence that would be not relevant for this particular proceeding.
I'm like twisted in my mind. I might be tired, but I don't follow. It should have never come in. It did come in. Now I have to deal with it. You tell me I'm cross. And
I don't think you're conflating, Mr. Steele, the bottom line basis as to why the initial guilty plea was rejected by our appellate court. I'm telling you that I don't know what the basis of that. I still don't know because I didn't read the opinion. The state didn't solicit that or elicit it from the witness. They only just said, hey, he pled guilty on another thing a month later. But the relevant portion that the court heard was the fact that if the jury wants to believe it, is the why as to what Mr. Winfrey may or may not have gotten. And that's the only thing that I heard at this point in time.
I think that, from being a person who loves what we do and loves the courts, I think it's offensive to say and have an agent testify that a guilty plea occurred when everybody knows or should know that that guilty plea is not a guilty plea. It is struck, vacated.
Okay, and Mr. Steele, I'm kind of just telling you that the reason and rationale is not, that would be totally improper for us to get into.
Okay.
Wow.
I would agree about that, but I don't think that was the state's intention in asking that question. So I'll note your concern for purposes of the record, okay?
Okay, so I'm going to make a proffer then for about 10 seconds if I may. And I understand what you said. Of course, I'll follow your rule. But I was going to ask Agent Racy, I was going to take the opinion, and I would be perfect to the opinion. And you stated that this man pled guilty. The man actually wanted to go to trial. You can say yes or no. The man was then told by Judge Staley that she doesn't see him winning. She knows the people in Cobb County. They will not like him. He will go to prison. He's going to be sentenced for X number of years, whatever the opinion says, and then he can answer the questions. And I will then ask the court to strike that testimony again, like I did earlier. And I understand you're telling me it's not relevant. I believe that it should have never come in the first place, and the state of Georgia has misled the jury. He did not plead guilty a month later because we do not recognize that as a guilty. When I say we, our system of what we call just was not, it was perverted.
Okay, all right. State, hold on, Mr. Matthews. The state wish to be heard on that issue?
Yes, Your Honor.
Yes, Ms. Hilton.
Your Honor, first I want to direct the court to an order that was entered on April 9, 2024, in which there was an order in which we cannot discuss the appellate process. What is a fact is that Mr. Winfrey pled a month later. What the state's asked, which was my next question, and I forget how I phrased the question, did he have to plea again to the same charges? And he said, yes, approximately a year later, to show that there was something that occurred and he had to plea again. But the fact remained that 1 month later, he took a plea. Now, the reason why it was overturned, or the reason why that is the appellate process in which the court has ordered that we cannot discuss and that we cannot get into. What Mr. Steele is speaking of is the reason why it was overturned. That is not for this jury to determine. They can know he pled once and then he had to plea again, which is the plea that we had. Because what I can imagine is on cross-examination, if I did not ask that question, they would have crossed him on it. And so what I did was ask him about a fact, which was a fact. Which was a fact. And then did something else occur later on, which is also a fact. And if Mr. Steele is going to go into what occurred during the appellate process, he's going to be assuming facts, not in evidence, because that we never asked him anything about the appellate process.
When did I enter that order?
On April 9, 2024.
Okay, all right. So I've already dealt with that issue, Mr. Steele. I note your objection, so I don't believe that those questions would be relevant for this inquiry based upon my order. So, but I'll note your objection for the record, okay?
Of course. No,
All right.
I appreciate your kindness. Can I have 2 more statements for this, though? If you don't mind. I understand the ruling. I just want to make 2 more statements.
Yes.
Okay, thanks. First one is, I don't know how the state can say I was going to, or anyone, maybe I shouldn't speak for other people. I never had a conversation with the prosecution that I would ever cross-examine a witness on a coerced guilty plea.
You made a proffer, that's all. I mean, I don't think we need to spend more time with it, but
well,
I'm good.
they took the wind out of the sails. I never, ever was going to do that. Number two, based upon your ruling, I understand it, and I'd just like you to, I'm going to move for a mistrial because I can't cross in it. If it's denied, can you just do what I've been doing? Just
I'll deny the motion for mistrial. I'll go ahead and grant you, I will note that you've asked again for mistrial before the positing of the next question, which you've done. All right. Mr. Matthews, did you have something you wanted to
Yes,
tell?
Your Honor, I just wanted to chime in on that issue that's just been addressed by the court. I wanted to.
Which issue, sir?
That the Honorable Mr. Steele addressed with the court.
Which one?
Regarding the guilty plea.
Okay.
Or lack thereof.
Okay.
So essentially, Your Honor, when the state had Agent Racy on the stand, they started with the jail call. They played the jail call, give you a Porsche and $250,000. Then they identified this person shot. What did you hear him say? Heard $250,000, Porsche purchase. What was significant about that call? And then, Your Honor, the state said, now did a month later, did Jimmy Winfrey plead guilty? He, in testimony, the response was he pled. Mr. Steele made an ask to approach. We approached. He made his points at the bench. After he approached, that's when the state furthered their question and said, hey, did something occur a year later, and did he take another plea? So that was afterwards. So in my mind, Your Honor, that sequence of questioning by the prosecution led the jury to assume and conclude that it was after he heard $250,000, after he heard that a Porsche was going to be given to him, he pled a month later. And I don't think we can unring that. And again, the Winfrey versus State 304 Georgia 94, what Mr. Steele is saying, which I tend to agree with, is that after that Supreme Court reversed that plea, it was not a plea. It was not a guilty plea on that date when he initially pled a month later, because it was reversed, and it was reversed because the Supreme Court determined that the judge improperly, under Uniform Rules Superior Court 33.5 paragraph A, determined that she improperly involved herself in plea negotiations, and there are a number of quotes, this opportunity is going away.
Okay, what does that have to do with the issue of what was just presented? I get it. The guilty plea was faulty for whatever reason.
And the state knew that, and they had a responsibility to know that. This is their
But we covered that on order on the 9th. We covered that at the bench. Mr. Steele already went through it. Do you have anything new you want to tell me?
Just that on the 9th, the state knew that. They knew that before they asked that question this morning.
Anything else, sir?
So I'm intimating to the court that door has been opened in our estimation. The court will have to rule on it.
I don't believe that door has been opened. I believe that at this point in time, it's going to stay closed. Okay? But I'll note your objection for the record.
Thank you, Judge.
All right. We're in recess till tomorrow morning.
Okay, now I'm getting ready to play the actual opinion of the Supreme Court of Georgia, Supreme Court of Georgia on this. Okay, I hope you guys can hear it. Let me know if you can't hear it. I'm gonna play it now. Put your hands up if you can't hear it. Let me know, okay? One second. Let's see if it's gonna show my stuff. Hold on a second. Let's see if it's gonna read it. All right, y'all ready?
Winfrey v. State 2018. Supreme Court of Georgia. Winfrey v. the State. S17G 1270. Decided June 29, 2018. Stephen H. Sato, Matthew K. Winchester, for appellant. D. Victor Reynolds, District Attorney, Michael S. Carlson, John R. Edwards, John S. Melvin, Greg M. Jacobson, Assistant District Attorneys, for appellee. Jeffrey Scott, Jeffrey E. Goertz, amicus curiae. Appellant Jimmy Carlton Winfrey pled guilty to 6 counts of violating Georgia's Street Gang Terrorism and Prevention Act in connection with a drive-by shooting of rapper Lil Wayne's one tour bus on Interstate 75.2. Winfrey now appeals, asserting that the trial judge properly participated in plea negotiations in violation of Uniform Superior Court Rule, USCR 33.5a, and that his plea was involuntary on the basis of that participation.
Okay, why it stop? Why my thing stop, y'all? Hold on. Ugh. Hold on, y'all. I'm trying to get it to play. All my my gurus. Trying to get it to play. Hold on a second. Hold on. It stopped playing on me. Okay, let's go do this. It's not playing. Why it's not playing, y'all?
Appellant Jimmy Carlton Winfrey pled guilty to 6 counts of violating Georgia's Street Gang Terrorism and Prevention Act in connection with a drive-by shooting of rapper Lil Wayne's one tour bus on Interstate 75.2. Winfrey now appeals, asserting that the trial judge properly participated in plea negotiations in violation of Uniform Superior Court Rule, USCR 33.5a, and that his plea was involuntary on the basis of that participation. We agree, and we therefore reverse Winfrey's convictions. 1. Winfrey entered his plea during a pretrial hearing, where the status of his plea negotiations was put into the record. The prosecutor advised that the state had made 3 offers, each of which Winfrey had rejected, and that no additional offers were anticipated. Defense counsel explained that he had discussed the offers with Winfrey ad nauseum, but Winfrey was hesitant to enter a plea because of the effect Gang Act or RICO convictions might have on his parole eligibility, and therefore, he was ready to proceed with his pending motion. The trial judge then stated in part, his opportunity is going away. Go to trial, and you get convicted. There's not going to be any of me being concerned about when you parole out. I will not be concerned about when you parole out. I will not be able to impact what count. Only a jury can impact what count you get convicted on or don't get convicted on. So that's for your team to figure out. Whatever they say you're guilty of, I'm going to sentence you. And I'm not going to worry about when you get out of jail, because it's not my concern. My concern is you went to trial. You didn't take any responsibility for what you did or did not do. It was proved if you get convicted of what you did do. I'll take that as truth, because a jury said so. And I would also take into account that you didn't take responsibility for what a jury says you did. And I won't worry about your parole eligibility. And if you want to look around and see what happens to people in gangs in Cobb County, Georgia, you can look at what happened last week to the guy who went to trial and got convicted and pulled. Was it 50 years? Prosecutors, 100 to serve 50. Judge, the court, there you go. These guys tried him. So I'm not judging them. That's what she did. I'm a whole different person, and you're sitting over in jail listening to everybody shoot their mouths off about this judge, and that judge, and the other judge. We all have reputations. My reputation is not that I'm an easy judge. I know it, you know it. The whole community knows it. So if that's what you want to go up against, be my guest. You've got an offer. It's about ready to evaporate. You're not coming back to there unless you convince a jury of people from Cobb County, Georgia. You didn't do most of this. There's such a thing as winning a battle and losing a war. If you think you're so smart and you've got it all figured out, you go to trial. Let's say you get acquitted on. How many counts are there? 27. So let's say you get acquitted on 10 and convicted of 17. You add it all up, it's still a mess of time. And I don't care when you get paroled. It's not my job. It's not my function. My job is public safety, and my job is constitutionally a correct trial for everybody, which I will do. Once that's done, whatever they say you deal with, I'm going to worry about public safety. So, y'all might want to talk a little bit more, but otherwise we're going to do motions in about 10 minutes. When the proceeding reconvened approximately 1 hour and 20 minutes later, Winfrey had agreed to what his attorneys have consistently characterized as the state's previous plea offer, and the trial court accepted the plea after thoroughly questioning Winfrey about the voluntariness of his plea and providing an extensive explanation of his rights and the consequences of entering a plea. 3 Winfrey was sentenced to 10 years to serve and a consecutive 10 years on probation. Winfrey filed a timely notice of appeal contending that his plea was involuntary because the trial judge improperly participated in plea negotiations in violation of USCR 33.5a. On appeal, the Court of Appeals first considered its own jurisdiction to decide the case and correctly concluded in the face of a challenge from the state that a direct appeal is a prescribed way to challenge the guilty plea. Winfrey v. State, 340 GA, App. 344, 345, 795 SD, 2D 752, 2017 citation and punctuation omitted. The court went on to explain that our appellate courts have made it equally plain that under these circumstances our review is limited to only those claims that can be resolved by facts appearing in the record, and that this case met that standard. ID citing Smith v. State, 287 GA, 391, 402 403, 697, SE, 2D 177, 2010. Turning to the merits of the appeal, the Court of Appeals concluded that the trial judge did not improperly interject herself into the negotiation process, but added that it did not condone the trial court's comments, which appear to violate the spirit of USCR 33.5a. Winfrey, 340 GA, at 349 to 350 795 SD, 2D 752. Nor did the trial court's comments render Winfrey's plea involuntary, according to the Court of Appeals, because he trial judge never explicitly told Winfrey that he would be facing a longer sentence if he rejected the state's offer and went to trial, even though she strongly suggested that result. ID, emphasis supplied. We granted certiorari, posing a single question to the parties. Did the trial court impermissibly participate in Winfrey's plea negotiations? We conclude that the trial court did participate in Winfrey's plea discussions in violation of Rule 33.5a in spite of the fact that many of the court's comments were implicit rather than explicit in their meaning. We also conclude that the level of the court's participation was so significant that it rendered Winfrey's guilty plea involuntary. 2. The trial judge should not participate in plea discussions. USCR 33.5a. In addition to the error inherent in a Rule 33.5a violation, judicial participation in plea negotiations is prohibited as a constitutional matter when it is so great as to render a guilty plea involuntary. State v. Hayes, 301 GA, 342, 345, 801 SC, 2D 50, 2017, quoting Pride v. Kemp, 289 GA, 353, 354, 711 SC, 2D 653, 2011, emphasis supplied. CF in Re SF, 312 GA, App. 671, 673, 674, 719 SE, 2D 558, 2011. Trial, court violated Rule 33.5a by inappropriately participating in plea negotiations, but the court's participation in this case was not so great as to make SF's admission involuntary. These cases indicate that, in some cases, a trial judge may violate Rule 33.5a without rendering a plea constitutionally involuntary. This conclusion is consistent with our treatment of other rule violations. See e.g., Arnold v. State, 292 GA, 95, 97, 734 SE, 2D 382, 2012 failure of trial court to follow USCR 33.8 by informing defendant of mandatory minimum sentence did not render guilty plea involuntary. Smith, 287 GA 400, 697 SE, 2D 177 unless defendant can show harm or prejudice from violation of USCR 33.8, requiring judge to inform defendant of potential immigration consequences of guilty plea. Defendant is not entitled to withdraw guilty plea. Adams v. State, 285 GA, 744, 747, 748, 683 SE, 2D 586, 2009 violation of USCR 33.9, requiring factual basis for guilty plea, did not result in manna, est injustice invalidating guilty plea, State v. Wooten, 273 GA, 529, 532, 543 SE, 2D 721, 2001 violation of USC R 3.1's requirements regarding case assignments neither violated defendants' constitutional rights nor harmed whether the trial judge violated Rule 33.5a, therefore, will not always settle cases like this, where the voluntariness of a defendant's plea is the dispositive constitutional issue. Accordingly, we must consider not only whether the trial court impermissibly participated, but also whether that participation was so significant that it led to an involuntary plea. Several factors have been consistent in this court's involuntary plea cases involving trial court participation in plea discussions. First, there has been evidence that the trial court threatened the defendant that he would receive a stronger sentence if he were convicted after trial. C.E.G. Pride 289 GA at 353354 711 SC 2D653 CF. Hayes 301 GA at 347 348 801 SD 2D50. Here, we agree with the Court of Appeals that although the trial court never explicitly told Winfrey that he would be facing a longer sentence if he rejected the state's offer and went to trial, the court strongly suggested that result. Winfrey 340 GA App at 349 350 795 SC 2D 752. We disagree, however, that because the trial court's strong suggestion of a harsher sentence was not explicitly stated, the judge did not improperly interject herself into the negotiation process. ID. Let us be plain, if a trial judge communicates, either explicitly or implicitly, to a criminal defendant that his sentence will be harsher if he rejects a plea deal and is found guilty at trial, then Rule 33.5a has been violated and the plea may be found involuntary. C.E.G. McDaniel v. State 271 GA 552, 553, 522 SE 2D 648 1999. A trial court stated inclination as to sentence may skew the defendant's decision-making. Emphasis added. Cherry v. State 240 GA App 41, 43, 522 SE 2D 540 1999. Impermissible participation in plea negotiations. Although trial judge did not expressly state that defendant's sentence would be harsher if he did not plead guilty, because the judge did comment that the recommended sentence was too lenient and suggested that a decision by the defendants to proceed to trial would be unwise. Emphasis supplied. In other words, see comments by the trial judge that reinforce the unmistakable reality that a defendant who rejects a plea offer and instead opts to go to trial will likely face a greater sentence are impermissible. Gibson v. State 281 GA App 607, 609, 636 SE 2D 767, 2006. Emphasis supplied. Several Court of Appeals decisions also demonstrate that trial courts should not communicate to defendants that they had better accept plea offers because convictions after trial would, not could, result in harsher sentences. In McCraney v. State, for example, when the defendant asked the court what sentence would be imposed if he went to trial, the judge responded, "Why don't you try it and let's see." 335 GA App 548, 548, 782 SE 2D 453, 2016. Then, shortly afterward, the judge said, "Why don't I make it life?" and later stated, "I'll be glad for you to go to trial because I promise you I'll be your judge." ID at 549, 782 SE 2D 453. Punctuation omitted. The Court of Appeals correctly found that the trial court's participation in plea discussions was so great as to render the defendant's plea involuntary and reverse the denial of his motion for an out-of-time appeal. ID. See also Cherry 240 GA App at 44, 522 SE 2D 540. Plea involuntary where judge suggested that a decision by the defendant to proceed to trial would be unwise after previously commenting that plea offer was too lenient. Similarly, in Gibson, the Court of Appeals reversed the Superior Court's denial of the defendant's motion to withdraw his guilty plea because, although the trial court appropriately informed the defendant of the maximum sentence, It went further by advising the defendant that the court would not give him the same sentence considerations in the event that he opted to proceed to trial, rather than accept the proposed plea. 281 GA. App. At 610, 636 SE, 2D 767. See also Scomer v. State, 183 GA. App. 308, 309, 358 SE, 2D 886 1987 withdrawal of guilty pleas appropriate following judge's statement that while he would consider giving the appellants probation if they pled guilty, he would not consider giving them probation if they stood trial and were found guilty by a jury. In Hayes, on the other hand, we found no error in the trial court statement that if the defendant rejected the plea offer, we are going to have a trial, and you are facing 20 years, and you would serve every day of it if you are found guilty. And that was the sentence imposed by the court. 301 GA at 343, 801 SE, 2D50, punctuation omitted, emphasis supplied. Instead, we found that the trial court's careful and repeated use of conditional language was appropriate, where the trial court merely advised the defendant of the mandatory sentence he was facing as a recidivist were he convicted at trial. ID at 347, 801 SE, 2D50. The trial court's explanation of the potential maximum sentence was carefully expressed in conditional language, avoiding any positive statement of what sentence might be imposed after a trial. ID at 348, 801 SE, 2D50. So the trial court in Hayes merely informed the defendant of the potential maximum sentence he was facing as a recidivist and the potential consequences of his decision, without communicating whether that sentence would likely be imposed. ID. Similarly, in the interest of SF, where the Court of Appeals found a Rule 33.5, a violation, it also found that the violation did not render the juvenile defendant's admission involuntary, because in informing the juvenile that he would face the maximum sentence if he rejected the plea offer, the judge did not make any threats of a longer term of confinement if the juvenile chose to go to trial. 312 GA. App. At 672 674, 719 SE, 2D 558. The key distinction, then, is whether the trial judge threatens that a sentence will be harsher after conviction if a plea offer is rejected, or advises that the sentence may be harsher. The former should not occur, and it is of little significance whether the trial court accomplishes at communication with explicit or implicit language. This holding comports with Georgia court's longstanding and recently reiterated recognition of the difference between telling a defendant that he could be sentenced to up to the maximum statutory sentence, and telling a defendant that he would be sentenced to the statutory maximum if he forgoes a plea and is convicted at trial. Hayes, 301 GA at 345, 801 SE, 2D50, emphasis in original. See also Scomer, 183 GA. App. At 309, 358 SE, 2D 886, stressing the enormous difference between being reminded by the state that rejection of a plea proposal may result in a greater punishment and being told by the trial judge that a rejection of a plea proposal will result in greater punishment in the event of a conviction by a jury. Emphasis in original. The comments in this case crossed the line. The trial court made repeated statements that referenced the judge's own proclivity to sentence harshly, along with other statements strongly implying that if Winfrey were found guilty by a jury, his sentence would be, not could be, harsher than that recommended in the plea offer. Specifically, the court told Winfrey, if you want to look around and see what happens to people in gangs in Cobb County, Georgia, you can look at what happened last week to the guy who went to trial and got convicted and pulled 100 to serve 50. There you go. These guys tried him. The court went on to imply that her reputation would mean an even harsher sentence. I'm a whole different person. We all have reputations. My reputation is not that I'm an easy judge. I know it, you know it. The whole community knows it.
Hold on a second, y'all. This thing keep stopping. Hold on. I gotta figure out where she's at. Okay, let me go from here. My reputation. I guess it stops after a while. Hold on. I'm letting this thing read it for me. Keep stopping. All right, let me go ahead and let this one read it. All right, here we go.
My reputation is not that I'm an easy judge. I know it, you know it. The whole community knows it. These comments may not have explicitly stated that Winfrey would receive a harsher sentence if convicted after trial, but this monologue was far more than the mere explanation of the potential maximum sentence carefully expressed in conditional language that we approved in Hayes. The implication was unmistakable. If Winfrey rejected the plea offer and the jury found him guilty at trial, he would be sentenced more harshly. 4C Gibson, 281 GA. App. At 609, 636 SE, 2D 767. Plea rendered involuntary by trial judge's comments that reinforce the unmistakable reality that a defendant who rejects a plea offer and instead opts to go to trial will likely face a greater sentence. And even those comments were not enough. Instead, the trial court chose to re-emphasize the risks that Winfrey would take by going to trial. So if that's what you want to go up against, be my guest. That brings us to another point. Expression by a judge of a personal interest in giving the defendant a heavy sentence is another factor that Georgia courts have looked to in analyzing involuntary plea cases like this one. CEG, Pride, 289 GA at 353-355, 711 SC, 2D 653, McCraney, 335 GA, App. At 548-549, 782 SC, 2D 453. In Pride, the trial court informed the defendant that if he rejected the plea offer and was found guilty after a jury trial, then the court would stack the sentences and give him the maximum. 289 GA at 353, 711 SC, 2D 653. But the court went further by stating, I am happy to try him, and he is going to get a lot more. I would really much rather try him, frankly, so I can give him what I would really like to give him. ID at 353-354, 711 SC, 2D 653, punctuation omitted. We found that the court's repeated statements that it would impose a longer sentence if the defendant went to trial, including statements that the court preferred that he went to trial so that a harsher sentence could be imposed, constituted judicial participation so significant that it rendered the defendant's plea involuntary. ID at 354-355, 711 SC, 2D 653. The comments by the trial court in this case were similar in nature to those found inappropriate in Pride, in that they intimated a desire to sentence the defendant, and they were shortly followed by the additional statement, if you think you're so smart and you've got it all figured out, you go to trial. While not quite as direct as the court's comments in Pride, the colloquy in this case strongly suggested that the court would hold it against the defendant if he went to trial. Indeed, the judge's statements that if Winfrey wanted to go up against her reputation, then be my guest, and that he should go to trial if he thought he had it all figured out are very similar to the McCraney judge's invitation to that. Defendant, why don't you try it and let's see. 335 GA, App. At 548, 782 SC, 2D 453, punctuation omitted. Additionally, the trial court knew that parole was a key decision point for Winfrey, and specifically told him that if she were called upon to sentence him after trial, I don't care when you get paroled. Also remarkable was the trial court statement to Winfrey that he would have to convince a jury of people from Cobb County, Georgia. He didn't do most of this, an explanation that shifted the burden of proof from the state to Winfrey. But of course the state bears the burden of proving a defendant's guilt beyond a reasonable doubt, and the burden never shifts to a criminal defendant to present evidence of or to prove his innocence. See Estelle v. Williams, 425 U.S. 501, 503, 96 S, CT. 1691, 48 L, ed. 2D 126 1976, Sampson v. State, 282 GA, 8284, 646 SE, 2D 60 2007. It is entirely reasonable to believe that this burden discussion further impressed upon Winfrey that he should plead guilty, because he would not be treated fairly at trial. Taken in their entirety then, the trial court's repeated comments communicated to Winfrey, albeit implicitly, that if he rejected the plea offer and was found guilty by a jury, then he would, not merely may or could, receive a harsher sentence. We must conclude in light of these comments that Winfrey's guilty plea was involuntary. Judgment reversed. As the majority correctly explains, the statements by the trial judge about her propensity to impose especially harsh sentences cross the line drawn by Uniform Superior Court Rule 33.5. Insofar as her statements impliedly threatened Jimmy Carlton Winfrey with a harsher sentence if he went to trial, and were found guilty. Judicial commentary of the sort certainly could render a subsequent guilty plea involuntary, but only if it actually induces the accused to enter his plea. The record in this case does not establish that the judicial commentary in question induced Winfrey to enter his plea, and I cannot, therefore, go along with the majority and conclude that his plea was involuntary. I respectfully dissent. The majority concedes that a violation of Rule 33.5a does not inevitably render a subsequent plea involuntary, and that most certainly is correct. As the United States Supreme Court has explained, improper threats may render a plea involuntary, but only to the extent that the plea is induced by the threats. A plea of guilty entered by one fully aware of the direct consequences, including the actual value of any commitments made to him by the court, prosecutor, or his own counsel, must stand unless induced by threats or promises to discontinue improper harassment, misrepresentation, including unfulfilled or unfulfillable promises, or perhaps by promises that are by their nature improper, as having no proper relationship to the prosecutor's business, e.g., bribes. Brady v. United States 397, U.S. 742, 755-290 CT, 1463, 25L, ed. 2D 747 1970 citation and punctuation omitted. Emphasis supplied. See also Machabrota v. United States 368 U.S. 487, 493 282 CT, 510 7L, ed. 2D 473 1962. A guilty plea, if induced by promises or threats which deprive it of the character of a voluntary act, is void. Point 5. As the record presently exists, I cannot conclude the improper comments of the judge, in fact, induced Winfrey to enter his plea. To be sure, Winfrey entered his plea about an hour and a half after the judge made the improper comments, and that fact is some evidence that the plea was induced by the comments. But the record also shows that Winfrey, his counsel, and the prosecuting attorneys had been in plea discussions prior to the improper comments, and although Winfrey had rejected earlier plea offers, the record indicates that his rejection of those offers was driven in significant part by concerns about parole considerations, concerns that were addressed, at least to some extent, by the negotiated plea that Winfrey finally entered. The precise terms of the earlier offers that Winfrey had rejected are unclear on the existing record, but the record suggests that the plea that he eventually negotiated might have been substantially more favorable than those earlier offers. Point 6. Winfrey was represented by two seasoned criminal defense lawyers, neither of whom raised any objection when Winfrey entered his plea. At that time, Winfrey represented to the trial court that he was satisfied with the services of his attorneys, and his plea was made upon his own free decision after discussing it with his attorneys. Also in his plea colloquy, he confirmed that no one had made any promise or threat to get him to plead guilty. His awareness that it was his decision whether to plead guilty or not guilty, and his understanding that if he proceeded to trial, he would be presumed innocent and have the right to make the state prove his guilt beyond a reasonable doubt as to every essential element of the crime. 7 solemn declarations in open court carry a strong presumption of verity. Blackledge v. Allison, 431 U.S. 63, 74 297 CT, 1621, 52L, ed. 2D 136 1977. See also United States v. Stewart, 198 F, 3D 984, 987, 7th Ser. 1999. Entry of a plea is not some empty ceremony, and statements made to a judge in open court are not trifles that defendants may elect to disregard. These circumstances and representations support the finding of the trial court that the plea was voluntary, and as the record stands now, it shows only a possibility that the plea might have been induced by the improper comments of the judge. That possibility is reason to afford Winfrey an opportunity to present evidence of actual inducement, notwithstanding that such evidence would contradict his solemn declarations in the plea colloquy. See Fontaine v. United States, 411, U.S. 213, 215, 93 CT, 1461, 36L, ed. 2D 169, 1973. But Winfrey filed no motion to withdraw his plea, which would have given him an opportunity to expand the record. Consequently, we are left with uncertainty about whether the plea that he eventually negotiated was substantially more favorable than the offers that he previously had rejected. We know nothing about what he discussed with his counsel in the hour and a half between the improper commentary by the judge and the entry of the plea, and we do not have any explanation of the thinking that led Winfrey to enter his plea. For all we know, Winfrey was not influenced in any way by the comments of the judge. His lawyers disabused him of any concerns raised by those comments. He had been predisposed to enter a plea if a sufficiently favorable plea could be negotiated, and the plea that he ultimately negotiated met his pre-existing requirements. This incomplete record has convinced the majority that the plea was involuntary. 8 I am not so sure. Footnotes. 1. Also known as Lil Weezy, Lil Weasel, Lil Full Clip, Young Weezy, Weezy F Baby, Weezy F Crazy, Wizzy Fizzy, Mr. Coach Carter, and Mr. Shoot 'em Down. His given name is Dwayne Michael Carter Jr. 2. A grand jury returned a 27-count indictment against Winfrey, charging him with multiple violations of the Racketeer Influenced and Corrupt Organizations Act and the Street Gang Terrorism and Prevention Act, aggravated assault, criminal damage to property in the first degree, and possession of a firearm during the commission of a felony. As part of Winfrey's plea agreement, the state null-prossed the other 21 counts in exchange for Winfrey's plea of guilty to the 6 gang counts, and Winfrey received a sentence of 10 years to serve incarcerated with a consecutive 10 years on probation. 3. It is apparent from the record and briefing that there may be a continuing, albeit unrecognized, disagreement between Winfrey and the state regarding the time to serve aspect of the last offer preceding the colloquy between Winfrey and the trial court. And we have identified nothing in the record that definitively resolves the question of whether the time to serve was 10 or 20 years. It may well be that, considering all the circumstances in a particular case, substantial improvement in a plea offer following improper participation from the trial court could demonstrate that the defendant's choice to accept the plea was not an involuntary one. We simply do not conclude that this is one of those cases. 4. As this suggests, a judge cannot immunize impermissible threats to sentence a defendant more harshly simply by couching the threats in conditional language. 5. Cf. Colorado v. Connolly, 479 U.S. 157, 164 to 107 S. Ct. 515, 93 L. ed. 2D 473, 1986. With respect to allegedly involuntary confession, holding that a. Sent police conduct causally related to the confession, there is simply no basis for concluding that any state actor has deprived a criminal defendant of due process of law. Emphasis supplied. Pulley v. State 291 GA 330 332 to 729 SE 2D 338 2012. The voluntariness of a statement does not depend solely upon whether it was made in response to promises. The key inquiry is whether the alleged promise actually induced the statement that the defendant seeks to suppress. Citation and punctuation omitted. Emphasis supplied. 6. The statements of the prosecuting attorney at the plea hearing indicate that the plea eventually negotiated by Winfrey cut the years of incarceration by half from the earlier offers for Winfrey to plead to violations of the Street Gang Terrorism and Prevention Act. The statements of Winfrey's counsel at the same hearing suggest otherwise, and the record is, therefore, ambiguous on this point. 7. The record also includes a written plea questionnaire, on which Winfrey made similar and consistent representations about the voluntariness of his plea. 8. Although the majority says that a Rule 33.5, a violation does not always render a subsequent plea involuntary, its analysis and conclusion suggest otherwise. Indeed, if the majority meant what it says, one surely would expect the majority to address voluntariness distinctly before concluding that the plea in this case was involuntary. But instead, the majority says nothing meaningful about inducement, an essential component of a claim that a plea is involuntary, and having found that the judge's commentary violated Rule 33.5, the majority jumps straight to the conclusion that the commentary itself, without more, shows the plea to be involuntary. Grant justice.
Sorry, yeah. I was trying to get the rules, what that rule was. Okay, let me go ahead and get the last bit of it. Let me let it play. Hold on, sorry.
Although the majority says that a Rule 33.5, a violation does not always render a subsequent plea involuntary, its analysis and conclusion suggest otherwise. Indeed, if the majority meant what it says, one surely would expect the majority to address voluntariness distinctly before concluding that the plea in this case was involuntary. But instead, the majority says nothing meaningful about inducement, an essential component of a claim that a plea is involuntary, and having found that the judge's commentary violated Rule 33.5, the majority jumps straight to the conclusion that the commentary itself, without more, shows the plea to be involuntary. Grant justice.
All right. So this case was overturned in the Supreme Court of Georgia. Basically, they're saying that what the judge said made his plea involuntary. So because of what she said, she said something about if he had gone to trial, that basically the people would not, I guess with the reputation she has, she's going to give him more time because of the likelihood of them convicting him is pretty high because she knows the people in Cobb County area. So basically she did a scare tactic for him to take the plea. And she also told him when they find him guilty, which they will because the people don't like gangs in that area, that she's going to give him the maximum, and she don't care anything about parole or anything like that, that she was going to come after him. She's going to hit him hard with the highest amount on his sentencing. So for those facts, he decided to go ahead and he was pressured. Remember one of those questions they asked you, did anybody push you to do a plea, and they say no? Well, the lawyers didn't pressure him. The prosecution may not have pressured him, but what the judge was saying basically pressured him to changing his plea to plead guilty, because they said they sent him out for an hour and a half after the judge made her comment. I'm sorry, I'm yawning because I'm tired. After the judge made a comment, so they went and sat down with him for an hour and a half. I guess they must have went to lunch and all that and talked to him and stuff. And then he came back and he thought about it and basically took the plea deal. So that's what they're basically saying. So now, Steele brought it to the judge's attention that basically they're bringing up something without telling the facts of what happened with Roscoe's case. They have the jury thinking that Roscoe took a plea deal and didn't tell them anything about the plea deal was overturned. That's what basically Steele was coming to talk to them about. And that's why I wanted to play exactly what the opinion of the Supreme Court and why they overturned that particular, the negotiation plea deal. And he ended up getting out of jail. So, hey, Mr. Clean, how are you doing? That you got Dallas just having a good time over there. You know that, right? So, but that's what happened with the case. So anybody have any questions? Because I just wanted to bring that to you guys. Because anytime they talk about something in the courthouse and they reference something, I want to bring to you guys what the facts were, what happened, and certain things, so you guys can get a full understanding of what certain thing is. Because yesterday we talked about confrontational clause. We talked about that yesterday, and today we talk about what happened with that overturn of that case with Jimmy Winfrey. It's Dallas' birthday today. Yeah, it's almost over. She only have 1 hour left, 55 minutes. Yes, it is her birthday today, the 14th. Do they monitor the jury's IP address? Probably not. And listen, even if you monitor the IP address, if they have people living in their house, you can't control what the people in the house look at. Like, okay, if I'm on the jury, right, and my husband is not, he uses the computer. He watches the YouTube channels and stuff. Just because he's watching, you can't stop people from the house watching what they're watching. You just can't go in there and watch it. You get what I'm saying? You just gotta be like, okay, he's watching that over there. I'm not gonna go over there and listen to it, because if I listen to it, I'll be in violation of what the court says. And I just don't go. But you can't stop what happens in your household. Okay. So really, they can't really stop them. That's violation of privacy of their family and friends. Yeah, Annabelle, they cannot stop it, because remember that was one of the questions one of the jurors had asked. And he says just don't go inside that room that the person is watching that television show. You can't stop. I can't tell my husband, hey, don't go into YouTube. He's not the one on a trial. In fact, I'm not even supposed to tell him that, hey, I'm on a Young Thug trial. I can't even tell him that. I can't even tell him. I just don't go in there watching. Don't watch it. Now, that's gonna be like crying. That's kind of weird, right, y'all? Say you say one of the jurors married and they watch late night TV together, right? And they put YouTube stuff on, and the husband's in there watching it, or the wife in there watching it, and they're in the same bed, same room. How do they stop them? Do you think they can stop? Now, if y'all think the jurors are not watching, woo, you'll be a fool. I told Glass, said, girl, those jurors have been pillow talking. Slick seems like the bus shooting at the point at state. What if someone doesn't know someone is on the jury? I just started talking to them about the trial. How does that work? They're supposed to walk away, Paris. When you start talking about the trial, they're supposed to walk away and move on or change the topic or whatever. That's what they're supposed to do. They're not supposed to be engaging in a conversation about the trial with you. You can't unring the bell. You sure cannot unring the bell. They are on honor system. Green eggs and no ham. Okay, y'all. You have your phone all day long. And that's why he had told them take those apps off their phone. They can't make them take the app off. They can ask them, but they don't pay for this phone. They don't pay not 1 cent on somebody's cell phone. Do you know what I'm saying? Bo channel. You're right. Them young jurors turn in. I bet they are tuned in. Yes, tuned in. What's the jury's reaction that demonstrative? The state keeps wasting time drawing on. Well, yeah, you guys missed earlier. Dallas told you what she said. Well, I told y'all what she said. She said, quote, Mom, these jurors look hood. Thug don't have nothing to worry about. That's what she said to me. She said, these jurors look hood. Thug don't have nothing to worry about. The first thing she said to me, she saw them coming in. She looked at them. And she was like, and then listen, remember, she's been, watching the case like you guys on the outside. But when you're inside the courtroom, it's a different feel. It's a different feel about this. It's a different, you see a lot of like wasted time. You get to see the whole environment behind the camera and things like that. How did you feel Glanville was playing stupid about about them misleading you? He judged, huh? I'm lost on what you just said. Retype it. I'm lost. Maybe it's my reading, because people always say I can't read. So let me try reading again. How did you feel when Glanville was playing stupid about them misleading you? He judged. Okay, I'm lost. Retype that for me, please. Everyone on this planet could see through love in Glanville. Okay, will the yes man be back tomorrow? Yeah, he'll be back tomorrow. Y'all, she told me, I said to her, are you going to keep him up there for 3 or 4 days? She says, that's not my ministry. And guess what? It's her ministry, because tomorrow is 3 days, right? It's her ministry. Yes, miscarriage, unprecedented, never before heard of. Plus the judge is making them waste gas. Do you have a limited slot to appear in court? Do they have a limited slot to appear? No, they don't have no. Nah, it's not used this time. Oh, it's not me this time. Y'all know I be like messing up my reading up here, y'all, because I be seeing things I don't see. Bobby, Robert, what's going on? This is my powwow gang guy right here. Hey, let me read what Robert says. Robert says, what is the implication? Is the interference that hood people don't have honor and integrity? You know what, Robert? You always want to start. No, she is saying neighborhood, like neighborhood, meaning that they listen to Thug's music, that they're very familiar with Thug and stuff like that. That's what she meant, hood, not hood in a negative connotation. She's talking about hood like being from the neighborhood in the area. He's a homeboy favorite type of thing. That's what she said. Okay, so don't take it in anything negative. Ain't have nothing to do with honor or the integrity. She's just saying that basically that the hometown favorite type of thing. So it has nothing to do with integrity or honor. So stop it with that bull. You see, you come in here always doing this, and me and you fight. Does Huey family come to court? Huey has one individual. I think his girlfriend comes to court. His mother has not. I've never seen his mother there. I haven't seen any other family member except his girlfriend. Do you think any of the jurors are leaning towards the state side? It's probably, remember I told you that's one I think one. I don't know about everybody else, but I know one, definitely. Why are they off another week? They just had a week off for spring break. Well, the judge gave them a break, a week off, because the judge is doing another case, and that case starts Monday. He has to be in court for that. So, and also, there's the jurors. One of the jurors needed some time off. Remember, he made promises to jurors that he would accommodate them for time off. So that's the agreement he gave them. And because when they were becoming jurors, they asked those questions. Remember, they asked those questions, and he said he's going to make some accommodations. So he's fulfilling that. Okay. Next one is definitely me. I've been drinking. Okay. To Sylvia, Tall Glass have a request. What's your request, Tall Glass? They understand the culture. Thank you, Sierra. You understand what I'm talking about. But Mr. Robert always want to come up here and start some crap with me. Well aware of the BS. They understand. Thank you, y'all. Y'all understand what I'm talking about. He comes in here with some craziness because he always wants to fight. But you guys understand what I'm saying by that. What everyone needs to think about: if they took one of the biggest people in our city to trial and you was on your jury, you wouldn't go home and watch what happened when you're in the box. Okay. All right. Exactly. What? And then the thing is, they seeing who's holding them up, right? They sit there, they see who's asking question over and over and over. And that will piss me off as a juror. If that one side is the one that keeps keeping the people a long time, I'm like, hold on. This is like waste of time. I want to go back to my family. I can't do nothing. I can't talk to nobody. Who's doing this to me? Is it the state or is it the defense? The state is wasting a lot of my time. I would blame them. I'm just talking from my personal experience myself. Miss Sylvia, how is the judge on the bench? Do you think he in love? No, that man is not in no relationship. Stop making up stuff, y'all. Stop it. No, yeah, that man is not in no relationship with that woman. Stop it. Which one is Huey? Huey is the one that sits between Mr. Matthew, Mr. Matthew, the one you guys call Silver Fox, him and his son. That's Huey. Is the juror you say is always writing the teacher? I don't know. I don't know if she's a teacher. I don't know. I don't know her position. I like them. You highlights the comments as you read. I like when you highlight the comments. Of course, Michael. When Matthew's comment, wow, another case. Yes, he has the spa shooter. He has a spa shooter. That's a high profile case in Georgia. That's a very high profile case in Georgia. Hold on, y'all a second. Hold on. I gotta do something. Hold on. I've been downloading my what's the names, and I have to clean it up when I do that. Oh man, I forgot to change the title, the dates and stuff. Damn it. Oh, H. Hold on, y'all. H. There we go. What was yesterday's date? The 13th. Hold on a second, y'all. Hold on. I had to I download my stuff, right? Did I push my button to start today? Oh my God, I don't think I started my button today. Damn it. Yeah, I've been screwing up lately. I think I screw up. Hold on, y'all. I think I screwed up today. Yep. No, I did push the button. I did just push the button. Yeah, I did push the button. I didn't screw up. I just don't know why this one didn't record. All right. I'm coming to your question in a minute. I just have to clean my my disk. Okay, erase. Okay. I clean my disk every day so I can record the stuff in the courtroom. Okay. You say he can barely handle this case. Well, he's on the spa shooter. You know, the one that killed 8 people. In fact, in Cherokee County, he has been already found guilty. They're trying to give him the death penalty over here. In Fulton County. How did you feel when Glanville was acting stupid, like he didn't understand what Steele was referring to about guilty plea from Winfrey being introduced in a deceitful way by the state? How did I feel? I felt frustrated today. I was kind of like, come on now. Come on, I know you. Why are you not reading that stuff? You read everything else. 33 count RICO in Augusta already. Really? Okay. Well, how is it fair? How is it a fair trial for the defendant with all of these accommodations? It's not fair at all. It's not fair. I feel bad for whoever case he's over. Hey, Mel. Let's see. Slick says, if you didn't believe the judge was biased before, he definitely showed it today. He said the court believes the state was proven there is conspiracy. Slick, I explained that to you guys earlier, what Chard said about that. Chard said that was pre-trial motion that he had already addressed. And it's only for evidence being brought in. If they can prove to him without on the preponderance of the evidence, he would allow it in. So based on what he put in, and remember the RICO they basically could throw anything in. Bad acts, old stuff that has been already adjudicated and all that. They can bring all of that in. They just have to prove it, okay? So he basically saying that they prove enough for them to bring those things in, those evidence. Because remember, the juror is the one who gets the ultimate decision of whether or not it's a conspiracy. He said it's a conspiracy to be able to let the evidence in. It's not that he ruled that the evidence that the state has proven it. He's saying the state has proven it enough for that evidence to be brought in as a conspiracy, and that's because Winfrey. They saying Winfrey is part of this gang. So he's saying all these people conspired together. So that's how he was able to bring those evidence in, because he's saying that they proved it for the pretrial to be able to bring it in, not the whole case. He's not saying that that it has been proven that actual conspiracy. No, he's proven enough for them to allow the evidence in those things. That's what he's saying. Okay. Can you play 2626 from today? Let's watch Love Messy in action. Also the guy D.A. Brown reaction for her and her facial towards the intern. We got to hold on a second on that. Okay. We're gonna, because I don't plan on being here all night with you guys. I got to go to bed. I've been on here an hour. And y'all always want me to do more, and then nobody get what I'm saying. But I've been here an hour and it's 11:23. You know I gotta get up in the morning. I'll do the reviews and stuff like that on another day. I'm just trying to get through y'all questions, okay? Have some mercy and kindness on me now. You hear my voice? It's getting raspy. All right. Fine A. She didn't even read the question to understand. She didn't even read the question to understand. Are you talking about me? Who's the guy next to the court reporter? That's Wesley. Okay, I guess find out about Little Rod later. Yeah. That's my first time hearing you cuss. You heard me cuss? And when did I cuss? I just cussed. Oh, Lord. See, I'm getting tired. I'm delirious now. I don't even know what the heck I'm saying. You have an external hard drive. Yeah, I got a whole bunch of them. A whole bunch of them, Manuel. A whole bunch of them. Look. Manuel, I'm telling you. Look. I have a whole bunch. I've been doing this case on. I got about 1, 2, 3, 4, 5. 5 external. And all of them are 5 terabytes and more. So you know I've been working hard. I've been doing this 2 years, since 2008, 22. I've been doing it a long time. Other cases basically open and shut. How do they bring old cases and reuse them? That's the way Rico gives them the opportunity to be able to bring bad acts, even uncharged bad acts. How can a defense petition be removed by its judge? Okay, let me explain again about this whole having the judge to be removed from the case. Steele made the motion, the request. He had 5 days to submit it to the courts. If Steele had submitted it to the courts, it would cause the whole case to go on pause. On pause, meaning that they would not go further on the trial. Steele says no, he doesn't want that for those guys because they've been in there long enough. That would prolong the trial. And say they decided to vote against it, then that's a problem. So that means they put the case on pause all that time. Nothing's being done, and they get a rejection, and he doesn't want to do that. But he still has the mistrial. He has motions in the higher courts that he's waiting on to get some answers on. But that doesn't stop the trial from moving forward. That part goes to another one, and he just waiting on the answer. Hopefully the answer come back real soon. He did that like in the beginning of the year. Okay. Do you think the guy should get death penalty? I don't know. I mean, he's already in jail. I don't know. I don't know. I don't know. I'm not a death penalty person. I'm a wrong person to ask that to. We love you, Lady Sylvia Silver. Thank you, Cindy, even though I jacked you up yesterday. The court lawyer. Okay. Drink some tea. I'm going to go to bed in a minute. I don't want to drink tea at night because for some strange reason, it keeps me from sleeping. Since this case is going to take 23 more months, why doesn't Steele file mistrial? He has filed one. What are the risks of defense filing a mistrial? They already filed one, so it's just a matter of time for them to get the approval. What is his role? Whose role? Wesley? Wesley is a staff attorney. He works under the judge. He gives case laws and stuff like that. He do research and things right while the judge is up there. Court lawyer, purple. Let's see. Okay. Two courts. No, it's not two court reporter. It's only one court reporter. That's Christine. That's only one court reporter. The other guy, he is an actual lawyer, staff lawyer. Do you think Doug will at least get the gang charges? At least will get the gang charge. The least. I'm not too sure. They don't want the gang charge because let me tell you, if you do the gang charge and say the RICO is proven, that's 20 years because they're looking for the highest. Because remember they did the recidivist on those cases, so you get the highest. It would be 20 years. Hey Sylvia, did you see your friendly urban neighborhood lawyer? Oh Lord, please don't do that to me. Don't do that. Don't put that person's name on here, Robert. Let me delete that comment. Gainesville doing the same thing. This whole circuit always saying what the state is trying to do or say. It's no different. Okay, hey Momo, good night to you too, Glenville. Okay, y'all, I did my last question. You guys have a great night. I just wanted to bring that up to your attention. And tomorrow we have court from 9 o'clock, supposed to 9 o'clock, but you know, it's 9-ish. 9-ish, right? So we're gonna reconvene tomorrow morning, and I'll be down there fresh and early for you guys, and hopefully it'll be over. Hopefully the defense will be up and doing the cross. Hopefully defense will be up and doing the cross. Okay. But I will see you guys. I thought they had to wait until appeal handle mistrial submission, learn something new. No, not that. But if they were doing the recruital of I can't say that word. Recusal of the judge, then there has to be a halt. Yeah, we don't mention that name in here. We don't mention most of these people. I try to stay away from that. That will ease some of the craziness. If you ever notice, I don't mention that person's name in here because then it's going to cause more. I get enough drama, get enough negativity being put in my chat. You know how many times a day I have to sit here and delete nasty messages, delete, block, delete, block, delete, block. And I used to respond to them. Now I found the best way to handle it. Delete, block, because I don't know. We got keyboard gangsters that be on the chat, and they just say all kinds of stuff. And I decided I'm gonna protect my peace, and how I'm gonna protect it. Delete, block, delete, block, delete, block, delete, block, delete, block. That's what I'm gonna do. It's easier that way. Because if I try to answer it, they're going to come back with something else. And it becomes so freaking draining. I have so much stuff that I'm doing and taking care of than to worry about what people think about me on YouTube. I used to be very, very sensitive, but I'm building stronger skin and realizing and understanding what Dallas said today. She's like, Ma, they're watching you. They're talking about you. You don't even know who they are. You don't even talk about them. So these gangster, keyboard gangster could go on somewhere, but I'm not going to let it get to me. All I'm going to do is delete, block, delete, block, delete, block, delete, block. So, I have a lot of plans for you guys. I'm trying to I'm trying to stay structured. I apologize for not coming on at 7:30. We did say 7:30 is the time. We're going to come on every night to do the nightly recap. We're going to do the afternoon one, but if we don't have lunch, there's not going to be a lunch recap. This is when you guys bring me the question and I try to answer the question. And anything I don't know, I go and ask the attorney. Just like today's question, I go and ask the attorney and they tell me what it is and stuff like that. And some of you guys gave me some stuff, and I thank y'all for it. Thank you. I want to give a shout out to my girl. I think Gigi. Gigi sent me some stuff today, and hold on. Let's see. Yep, it was Gigi. Gigi sent me some stuff today, and I forwarded to the appropriate people. So thank you, Gigi, for doing that for me. So I think that's it. Anybody else minds are clear? Any question that you guys, some burning question before I shut this down? Do you have any burning question that you want to ask me about? Remember, y'all, I'm learning just like you guys. The only difference between me and you, I'm sitting in the courtroom, but anything I don't know, don't understand, I go and start reading, researching, or ask questions if I don't know. And I know a couple of you guys was asking about Chard. He had some place to go today. He had an appointment. Somebody said he had a hearing at 4:45 or something like that. Somebody said, but it was after 4 when he left. So I don't know. I'm doing good, Kim. I'm doing good. But I know you guys recently heard about DJ Academics, right? I have the paperwork on that, but I'm not going to read it here. And I have some other paperwork that if you guys want me to read, I'm going to do all the other crazy stuff on the other channel. So if you guys have not subscribed, please subscribe to my backup channel. That's the one that I'm going to speak like off the chain type of thing. Yeah, so I will, if you guys want me to read that, I can read that tomorrow. But you gotta let me know. We all can see the bias and the judge is doing. Let them know. Oh yeah, they know. Oh my God. Let me tell you, I tell them how much you guys encourages them. Anything y'all tell me to do, I go and do. You know me, I have no problem. I will let them know every single time. And Mr. Steele says he appreciates you guys. Because I tell him what you guys are saying as a group, the majority, and he appreciates it. Trust me, he appreciates everything. He does ask, what's the temperature with you guys and how y'all feeling about certain things. And he thanked you. He did. Y'all see how kind that man is. So keep them in your prayer. It's a hard battle. Keep them in the prayer. Keep the family, Jeffrey's family in prayer too, because they got a lot that they're dealing with. A lot. I told you that his nephew is upstairs and the craziness that happened. Those who missed earlier live, it's on the live when I talked about some of the stuff that was happening up there. So it's hard for me to do both cases at the same time. But tomorrow I think I'm gonna go see about it. Next week I'm gonna go upstairs and see how that case is going because I'll have the whole week off. Them being off does not mean me being off. I'm still gonna be out there working. Put your channel in the chat. Oh, you want the other channel? Okay. Steph just put it in there. There it is right there. That's the second channel. That's the channel I really like. Don't judge me, y'all. Please don't judge me. But that's a different type of channel. That's the channel y'all gonna get the raw. Okay? So don't judge. That's my alter ego. He definitely knows the law. Jeff is good hands. Pray for everyone in the courtroom and their family. Definitely pray for everybody. Not just one, just pray. But just do an extra prayer for that family because they got a lot going on. A lot. What you have on there. Look, Mr. Clean, that channel is like when you go on the infamous slide channel, what's done in the slide channel, stay like the Vegas saying, what's done in Vegas, stays in Vegas. What's done on the slide channel stays in the slide channel. Okay. That's the channel. You might hear a couple of bomb words. Oh, well. You don't see it? Steph just put it in there. That's the other channel is just when I get real like down to earth and there's no filter sometime in that channel. Okay. Not that, I don't fly way from my personality, but you'll see some stuff and hear some stuff in there. You'll be like, Miss Sylvia, what? Not you. Okay. Say I be stripping. No, I don't be stripping. But I'm going to bed, y'all. It's 11:38. You guys have a great, great night. Sleep well. Let's do our little prayer. May the Lord watch between me and thee while we're absent one from another. You guys have a great night. I'll see you all in the morning, if the Lord's willing. Good night.